carrying their newborn baby with them. So they've been here all day, very passionate about this. I've talked to them several times on the phone. I would like to hear from them at the appropriate time.
Is there objection? Chair hears none. That would be Sky Spalding. Is that right? Is it your name's on my list? Welcome.
Thank you. Thank you guys for staying up here tonight.
Scott, give us your full name and tell us you're here in your own interest, not on behalf of some group or.
I am here as a resident of West Virginia.
Very good.
Yeah, so my name is Sky Spalding.
Do you solemnly swear or affirm, Scott, that the testimony you're about to give the committee would be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you so much, and the floor is yours.
All right. So some of you may be wondering what qualifies me to speak on this bill. I am a child of divorce. My parents divorced when I was about 1 year old. I am a child of abuse. My mother married an abusive man when I was 2, and I endured over 8 years of that abuse. I was forced to move across the country at the age of 10 when my mother decided to move to Las Vegas, and even though I desperately wanted to stay in West Virginia, I was unable to. My mom told me I could stay with my dad, and the day before the move, she made me get in the car and on the plane the next day, and we were nearly 2,500 miles away from my dad in my hometown. And that's under the current law. And it sounds like it would also be the same under the one that's being presented with the strike and insert. I have a psychology degree and a master's in social work from WVU. I've been extremely involved in an ongoing custody case for my daughter, well, my stepdaughter. I'm currently pregnant. And under the current code, my children will only be able to see each other 28.57%. Over the course of 9 years, which is when my stepdaughter turns 18, they will have only spent 2.5 years together total. Under this strike and insert, we have no hope to change it, and our judge wasn't even required to state why she decided less than 35%. I have experience, and I consider myself an expert on what it is like for children of divorce because I've lived it, and I've been through the gamut. Family law attorneys' expertise lies solely in getting the most custody they can for their clients. And family law judges do not follow up with the children of cases they decide to see whether their decisions were best. They typically have no idea what happens after that case is decided. While I appreciate what Judge Rock was saying about how parents can do 50-50, agreeing amicably is not always the case. It only takes one parent to be scorned and to try to get more than 50% custody and fight for it. And as she said, there is usually one loser. There doesn't need to be though. If two parents are fit, why is 50-50 not the presumption? I urge you to vote against the strike and insert amendments for HB2363. It completely takes away all meaning of the bill. It takes away the definition of what the best interest is for a child and keeps arbitrary language. In a situation when there are two fit parents, neither parent should have to prove why they should have equal custody. It should be the presumption from which a judge can deviate on a case-by-case basis, because a presumption is not a mandate. The bill proposed by the House allows judges to use their discretion just as current code does. It's not different. Removing the 50-50 presumption will remove the language that supports maximizing parenting time, which multiple studies have shown to be in the child's best interest. Nielsen is one of over 110 social psychologists who agree that maximizing parenting time is in the best interest of children, based on the latest studies. I'm not a rocket scientist, but maximizing parenting time with each child would be with each parent would be 50-50. I believe that's as maximum as one can get without tipping the scales. In addition to the studies regarding how children thrive when parenting time with both parents is maximized, another social psychologist, Fabricius, interviewed adult children of divorce, like myself, and 93% of those children who had 50-50 custody said they preferred it. 70% of children who did not have it said they believed it would have been in their best interest. I fall into this category. Out of every 7 years, I saw my father for 1. He got me 2 nights out of every 14. It was not enough, and it's still a normal thing that happens today. I heard a claim that 50-50 is where custody litigation currently begins. This is patently false, as it is not written in the current code. Currently, many judges use a form FC-128, which takes into account caretaking prior to a separation, and it is an actual template. Boxes to check, I believe is what the judge said earlier. It does not account for the natural changes that occur when 2 people with a child separate. If there is a claim that this is an unwritten rule, then there is no reason to not make it a written rule. If for some reason 50-50 is not in the best interest of the child, this bill in its current form, without the strike and insert, protects the child by allowing reasons to deviate. Domestic violence is a reason to deviate. Under the current law, an abuser can assert their power and gain 100% custody of their child to hurt the abused parent. Under this bill, the victim of domestic violence has a better chance of getting 50% custody, and upon the preponderance of evidence, which is, by the way, the lowest evidentiary standard, can gain full custody to their child. Preponderance of evidence is not too much to ask when you're stripping a child and parent of their constitutional right. The clause for modification should stay intact as well. A substantial change of circumstances is not defined under the current code, and cases with similar facts can and do have decisions that widely vary. Children whose parents separated in 2020 deserve to have their best interests considered just as much as children who separated this year or any year in the future. There are other ways to amend this bill that will not negatively affect all children whose cases have been decided prior to the hopeful adoption of this bill. I would be happy to even offer an option right now. This is not a bad dad's bill, or anyone that puts forth the assumption or assertion that it is only asserting that the current code or those who enforce the current code favor mothers. Anywhere from 70% to 90% of custody cases that go to trial end with a mother having primary custody. If you look at the National Data Archive on Child Abuse and Neglect, in West Virginia, this is specific to West Virginia, perpetrators of child maltreatment by sex, 39.7% are male, 60.2% are female. If you look at nationwide child maltreatment, 22.6% is father only, 39% is mother only. When you factor in their new relationships, their new partners, 23.7% abuse is happening with the father or with the father and the non-parent. 45.4% is happening with the mother or with the mother and the non-partner or the non-parent partner. That's the category I fell in when I was being abused. Nationwide child fatalities, 29.2% at the hands of the mother, 14.2% at the hands of the father. When you look at domestic violence in West Virginia, 33.6% of West Virginia women and 41.2% of West Virginia men experience intimate partner physical violence or stalking in their lifetimes. You heard me, I said more men than women. This domestic violence issue isn't a female versus male issue. It is a reason to deviate, but not a reason to prevent a bill for children to get equal time with both parents. Not to copy Senator Randy Smith earlier, but all the arguments against this bill are if, might. We need to do what benefits the majority of children and trust that our law and the judge's ability to deviate when the situation calls for it will handle it. We'll handle all those if, might scenarios. Again, I strongly urge you to vote against the strike and insert amendment, which is essentially Senate Bill 79 disguised as an amendment, and move to pass HB2363 with the original language, as it is more in tune with the most up-to-date, with the most up-to-date scientific studies. I heard a lot of hopes for what judges will do, and like Jeb said, our kids deserve more than hope.
Scott, thank you. Let's see if there are questions for